Morning, Your Honor. Regina Garrett Caraher on behalf of Mr. Black, who's appearing via Zoom. Cody, can you state your name for the record?
Cody Black.
Your Honor, may defense counsel and I approach before we proceed any further?
Really? Okay.
I'm sorry.
Can you put all of us into a bench conference, please?
Okay.
Court calls the case of the People versus Raquel Castellet.
If we have to do a 2-week adjournment, and I hate to do this, but could we have a brief breakout room with Your Honor and counsel?
Your Honor, I swear this is my last case.
I've got to start looking more angry because everybody wants to talk to me. Fine.
This is my last case for today, though.
Yeah, you've been in like 8 of the breakout rooms I've had. I get it. Okay.
No, I'm sorry.
I'll take the blame for this one, Your Honor. It's on me.
Okay. All right, this is Tana's fault. Can you put us into a breakout room, please? Thank you.
Thank you.
Okay, we're back on the record in the...
This judge has one of those personalities where the courtroom feels unpredictable for everyone involved. 1 second he's joking around, the next second he's laying down serious consequences. And honestly, that balance is probably why people either respect him immediately or completely underestimate him.
Preliminary exam.
Before he waives, Mr. Pollard is likely going to need to turn himself in. You've seen the bond violation?
Yes, Your Honor.
I had issued a bench warrant with no bond because of what was contained in that report.
This is the report from February 10th?
Report from February 10th.
Was there a warrant issued after the 7th of February?
Warrant I issued was on February 16th.
Okay, I did not know that.
So when is he going to turn himself into the jail?
Mr. Pollard, you need to turn yourself in on these bond violations. When will you be able to do that?
Well, I'm going to tell him, and I'm going to try to make it as convenient as possible.
Okay.
So how did I violate the bond? Hello?
Yeah, we're here.
How did I violate the bond?
We had talked briefly about it. Oh, go ahead, Your Honor.
Defendant failed to report for intake testing. Telephone to defendant, left a voicemail. Telephone the community corrections back on January 27th, stating that he did not know he was required to report. He was then at that time instructed to report on January 28th to submit to testing and return on January 31st for intake paperwork. Telephone the front desk on 1/28/22, stated he started a job and could not report to test. Formed the front desk to report for intake and testing on the 31st. On the 31st, you then failed to report and did not contact community corrections. On 2/1, they sent a bond report on. You failed to appear then in court on February 3rd, and a warrant was issued. The warrant somehow or another got canceled. Telephoned the front desk on 2/8 at approximately 4:20, was scheduled for intake on 2/9, and once again, you did not appear and did not contact community corrections. As of the writing, you have not completed intake or submitted to testing as was ordered. And that was on February 16th, or on February 10th. On February 16th, after receiving the report, the court issued a warrant. You still have not gone over, and I am almost a month out. Anything else you want to know?
No, I was dealing with CMH. I've been dealing with CMH, and I really didn't know because it's my first time ever having to on bond anything, and I didn't really know the procedures. So when I did go up
well, I'm explaining to you the procedures right now. And that is you need to report to the Washtenaw County Jail, otherwise we will come and get you. Which would you prefer?
I'll report. All right. Okay, I'll report to you.
Here's what I will do. I will adjourn this out 1 week. Probable cause conference will be adjourned to March 17th, 2022, 9 a.m. I am going to order that the defendant is to report
Good.
to
Community-
the Washington
correct.
County Jail. You are to, no, you need to report to the Washington.
What stood out to me here is that the judge wasn't yelling. He didn't need to. He literally walked through every missed appointment, every ignored instruction, every failed opportunity step by step. That's the scary part about court sometimes. Silence and details hit harder than screaming, and you can hear the defendant trying to explain it away like confusion or misunderstanding. But from the judge's perspective, this wasn't one mistake. This was a pattern.
I do not think I do.
I got a violation.
Oh yeah, you do.
For what?
No, I don't believe I do get the bond violation.
All right, here we go. Ms. Alberman was scheduled to report on February 4th for intake. She did not complete intake until February 7th due to being ill and unable to report in person. She was instructed to begin calling the DART hotline and report for weekly testing. She submitted an initial test on 2/10/22, which was positive for marijuana or THC. We didn't have a card. Her second test was also positive. Excuse me. Zeller was approved by the court to begin testing at on-site in Redford. She was advised to sign a release and have all tests sent to community corrections via fax or mail. And as of this date, she has not, the date of the report, which was 2 days ago, they have not received any tests, which means they have not received test results for 3 tests in a row.
That's a lie. That's a lie. Can I speak?
Okay, you want me to call the community corrections officer and say that they're lying in a report to the court?
No, I got Ms. Wild's text messaging who said that she did receive the test results from on site. I have a text message for that. I could screenshot it and email it to my attorney.
When did you receive that text message?
Right now. I got the text message from, scroll down here. Boom. This was, all right. Text message March the 1st. Text message Friday.
Is that text message indicating that they received the results from Redford?
Yes, she said she did. Yes, she did. She said she received the results and my little signature of admittance for the THC. And my magistrate, Alicia, already in my arraignment said that I could use my medical marijuana, because when I went to jail, I had my medical marijuana
You have
card
to,
with me.
you have to
I had the card
have
with
the
me.
card, ma'am. You have to give the card to community corrections.
I did. I gave it to
Not
Ms.
so-
Wiles the day that I
Okay.
signed up for it. She took a copy of it. Ms. Wiles has a copy of my medical marijuana card that I've
Okay,
had for 2
I'm
years.
not, ma'am, did you listen to what I read? I am not so much concerned about the marijuana.
Mhm.
I don't
And I've
see
reported-
that they didn't violate you for that. I don't have test results.
I've given at least three results. There was 2 at community corrections, 2 with Ms. Wiles that I did there, and I did 1 at the on-site. And the only
Counsel,
reason why
what did you want to do with this? Because I'm not going to sit up here and argue with this.
Okay.
What do you want to do with this?
Right. Well, I was unaware of the bond violation before, like I'd said, so I didn't have a chance to speak with her, but it sounds like she does have some proof possibly. If we could maybe just keep the prelim date, and if she can get that over to me, I can get it to the court.
I need to get what to you?
The text messages that you say that you have from Miss Wild, if you can
Yep.
give me screenshots.
Here's
of
what
those.
I'm going to do. You need to get that over there, get all of that corrected with community corrections. I'm not setting it for prelim at this point in time because otherwise I'd be taking other action prior to setting that. I'll adjourn it out 1 week to the 17th. She needs to have all of that corrected and get all of that information if she's saying this report is wrong.
Also, can you,
Bond will continue.
I have one more thing though for the testing. Can you re-enter that I am allowed to use my medical marijuana? Because Magistrate Fink,
If
when I went to
they have
arraignment,
it,
she approved it already.
Ma'am, you have told me they haven't. So I'm not re-entering anything. If you have a medical marijuana card, you would be permitted to use.
Ms. Wild said that that she didn't get it on record from the judge, from Mrs. Fink, when I did the magistrate. So
I thought you said that I thought you said Magistrate Fink said so.
She did, but they didn't see it in like the court, recording.
Ma'am, I am not doing anything. I've set you for next week. Everybody needs to get.
The second somebody says, "That's a lie," directly in court, you already know the situation is spiraling. But what makes this clip wild is that the judge actually stays surprisingly patient for a while. Meanwhile, the defendant keeps interrupting, keeps talking over people, keeps arguing technicalities, and you can almost feel the courtroom getting more tense every minute. That's something people watching from home don't always understand. Attitude matters in court. A lot.
Baker. Ms. Baker, will you please unmute yourself and state your full name for the record, please?
Alexis Baker.
You want to argue with me too, Miss Baker?
No.
Oh, okay. I'm just checking. All right. I'm just trying to figure out what I'm in for. Miss Baker goes, "Oh my God, no."
No arguing.
Okay.
Court calls case, People versus James Blake.
Jessica Blanche appearing on behalf of People.
Good afternoon, Your Honor. Chinazi Kiriakimaruli on behalf of Mr. James Blake.
Boy, talk about somebody that wants to argue with me. Where's
I've
Mr.
been practicing. I've been practicing.
Not you. I'm not talking about you, but now if you want to go, let's go. I'm about ready today.
You all warmed up now.
Yeah. I stay warmed up. All right. What are we doing on this case?
Your Honor, I have had an opportunity to speak with my client. We will be requesting an adjournment. For the record, there is an offer from the people. Is there an offer? We are in.
I'm not gonna lie. This part almost feels like a sitcom for a second. The judge already knows who's about to argue before they even start talking. You can tell he's dealt with this exact energy hundreds of times before. But underneath the jokes, there's still a warning there. Court is not the place to play games.
He's here. Mr. Boyce,
do you
Wyatt Boyce.
Do you have a medical marijuana card?
I do not. I was using marijuana before I was arrested.
All right. It's expired and he's testing positive and doesn't have a card.
And Your Honor, my notes from Community Corrections indicate that he was ordered to report on January 30th, 2022 within 24 hours. He actually completed intake on February the 7th, and the February 7th 10 panel had the positive THC, and we continued to have positive THC all the way to March the 2nd.
Okay, so my first question is the bond, was Mr. Boyce aware that there's a bond condition saying that he should not use marijuana? It's not illegal anymore. So on the face of it, that's not an issue. Only if it's a violation of the bond itself.
Right. If it's a violation of the bond. And I believe, yeah, because it's a DV, so I'm sure she had the standard conditions. And that is correct. He was not to use. It's on his release.
So the second question becomes, how long after he was arrested was he tested?
Well,
he didn't report for a week.
When he was tested on the 7th. Okay. And at least for the next 30 days, well, about 30 days, he's been positive.
All right.
And they had a discussion about, so that you know, Mr. Brown, because I know you don't have it. He did indicate that he had an expired card, but he doesn't. I mean,
And Your Honor, at this point, the people would just be requesting that he continue testing, and I'd request levels for the next few tests, and then we'll sort of go from there.
Yeah, no, that's fair. If Mr. Boyce could be told by the court that he's already been told that, but if he reminded not to use marijuana during the pendency of this case, as that is condition of his bond, I believe that he can follow that.
You understand that, sir? Because he told me, well, he told Community Corrections he hadn't smoked since intake.
Correct.
So whatever he had before intake was just some good stuff. I'm just saying, I don't know. I don't do it, so
Allegedly.
Allegedly, it must have been good. I don't know. It's hanging around. Didn't want to go home.
I was smoking pretty heavily beforehand.
Okay. All right.
So I just want levels, Your Honor, and for him to continue testing.
All right. I'll indicate defendant to continue testing. Now, what we're going to do with the case?
Oh, yeah, we're setting this. Yes, we're setting it for preliminary examination. Now, they say marijuana use makes your memory kind of funny.
You didn't even know my name this morning. So. I don't know what that's about. I'm just saying. All right, so you want a preliminary examination? Will it be by Zoom or in person?
Yeah, yes, please, Your Honor. By Zoom.
By Zoom?
Yes,
please. You gonna remember that? No, I'm just saying. Okay. Preliminary examination.
Do my best. I'm gonna write it down.
Yeah, okay, you do that. Preliminary examination will be by Zoom, and I guess so we can get, this is. March 22nd.
Can we possibly have the 29th, please, Your Honor?
As long as Mr. Boyce has no issue with that, he's out of custody. I don't see that as an issue. Is that an issue for you, Mr. Boyce?
What about 4 or 5?
Yes, please.
Will
that work for you, Mr. Brown?
It always works for me. Mr. Boyce, do you have anything scheduled at that time that will prevent you from participating?
No, I do not. And if anything comes up, this is more important than anything else. So that works for me.
All right, then.
I like the way he thinks.
This section is funny, but it also shows something important. The judge actually gave this guy a chance. He wasn't immediately trying to lock him up. He just wanted compliance. And honestly, that's something you see a lot in these hearings. Judges usually give people opportunities first. The problem is, eventually patience runs out.
Anderson, with on behalf of Mr. Thorns. Mr. Thorns, please state your name.
Patrick Thorns.
Your Honor, today's the date and time for probable cause conference. I am in receipt of a bond violation in this case, and I know the court is aware, but for the record, the defendant was first placed on conditions in October 2021. He tested positive for THC, cocaine, and amphetamines. 2 tests positive for all 3 of those substances in October. November, 2 tests.
Thank you.
Mr. Brown, you're not muted. 2 tests positive for those substances in November for THC, I should say, 1 for cocaine, another with an abnormal creatinine level. Continued positive tests for THC, and most recently on February 24th, he had a positive test for THC and cocaine, and then on March the 8th, he missed his sample. In this case, the court had previously cautioned the defendant about testing positive and had warned him a positive that he was not to be using cocaine. That admonishment happened on February the 3rd. He has been adjourning this case for several months. So at this point, I am requesting that the court revoke his bond and remand him to the custody of the Washtenaw County Jail pending any further hearing.
Your Honor, may I speak?
Ms. Anderson?
Thank you, Your Honor. Your Honor, unfortunately, I've not had a chance to make any contact with, any substantive contact anyway, with Mr. Thorns. I am in receipt of the bond violation report. It does indicate that there was a relapse and that he was to get back in contact with CCOP. I don't have any further information as to whether he's made that contact since the date of this report.
Your client wanted to talk. I don't know what you...
I would advise Mr. Thorns not to address the specifics of the violation.
Okay, yes.
If there's something else that you wish to address, Mr. Thorns, then we can move forward from there.
No, yes, I was released from prison in October of 2021. I've been out of jail since then. I haven't had any police contact. Yes, I did have a relapse. I'm not running from the state. I have a whole nother case that I'm dealing with that I'm on bond for. And the reason I wasn't able to get back with Brad was because the violation had came as in it was before it was after I got the message from Brad. I have class today. It's not like I'm running from the state or anything like that. I'm dealing with it in my own way. I have a lot going on. I'm just trying to get my life together, period. It's nothing. I'm not running from the state at all, period. I just had court the other day, and for this case, I'm trying to come. I really want to waive my preliminary examination and try to find a global resolution because I'm going to have Darlene O'Brien.
All right, look. Grand reality, you don't stop using, you're going to end up going back to prison. That's grand reality. What I'm going to do in this case is his probable cause, I'll adjourn it out 1 week to the 17th, 9 a.m. I will indicate, sir, that I am revoking your bond. I did admonish you to continue to use. The only thing that I would add, which makes it worse for you, is that when the cocaine disappeared, at least as a positive test, you had abnormal creatinine, which this court considers to be a positive. So you've been using a whole lot more when the cocaine shows up. So you need to report to the Washington County Jail by 6 p.m. this evening. If you fail to report, a bench warrant will issue for your arrest.
So I need to go report today?
You need to report to the Washington County Jail by 6 p.m. today.
Okay.
If you fail to report, so that you know, I'll issue a bench warrant for your arrest with no bond.
This ending changes the whole tone. The jokes disappear completely once the judge starts talking about cocaine use, relapse, and prison. And the hardest line in this entire hearing might be, "You're gonna end up going back to prison," not because it sounds dramatic, but because the judge says it like he already knows exactly where this road ends if nothing changes. That's the part that makes these hearings feel less like entertainment and more like watching somebody's life slowly collapse in real time.